When we talk about TrackGBV, we often get the question, why the Pacific? And are we doing TrackGBV anywhere else? To answer that, the Pacific was first because of our relationships. Whenever we take on new projects, we build relationships and thoroughly test our assumptions before proceeding. Over the past year, we have been doing just that to explore how TrackGBV could support access to justice in the Caribbean. Because these questions are both international and context specific, we have been very intentional about how we move forward scaling the program. So with that, I am thrilled to announce our final speaker, who will be touching on some of those questions about what TrackGBV could look like in the Caribbean, and specifically in Barbados. Justice Jacqueline Cornelius was appointed High Court Judge in Barbados in 2006 after 18 years as a practicing attorney at law. Prior to this, Justice Cornelius was a lecturer in law at the University of the West Indies. Justice Cornelius has a deep interest in judicial education and specialist courts. As chair of the Family Law Council since 2007, she has spearheaded the creation of the Family Court in Barbados. She was a member of the Sexual Offences Advisory Committee and the committee to draft the Gender Protocol for Caribbean judges, and has even drafted the Barbados Gender Protocol. She's a frequent speaker on gender and sexual harassment and violence, as well as family law, and has presented papers both locally and regionally on these topics. We are honored to have you here with us. Justice, over to you.
Thank you so much for inviting me. I want to thank ICAAD and the TrackGBV crew for including the Caribbean in this particular initiative. And I want to thank you all, comrades, colleagues, and fellow workers, as I say, in the human rights vineyard. And we are the people that your work is supposed to particularly affect. That would be the judges. So a lot of what's happening in the Caribbean is mirrored in what is happening in the countries that your project has covered. We have a similar background in the sense that we are, the English-speaking Caribbean is not very large. It's about 6 million people, and it can be quite diverse, but it is generally overshadowed by what's happening in the Spanish-speaking Americas. But we do have quite a different culture and a different background to some degree, generally being colonies of England, France, and Spain, but with that history being largely English speaking. And we do have Haiti speaking French and Guadeloupe and Martinique, which are prefectures of France. But the CARICOM region, of which Barbados is a part, is a specific economic and trade grouping. And we have a lot in common. And what we do have in common is a very, very shared history of violence, gender-based violence, and inequality and discrimination coming from our colonial past. So what can the dashboard look like in Barbados? Well, first of all, we have been engaged in a similar activity with the help of the Government of Canada and the Juris program, which is a program out of Canada which seeks to increase gender sensitive adjudication in our regions, especially in the English-speaking Caribbean, the countries of Jamaica, Barbados, Trinidad and Tobago, and Belize. Those are the countries in particular involved in this particular project. And what Juris did, we recognized, we came at it from a different angle than you did. You started from looking at the actual cases. In 2016, there was a baseline study funded by UNICEF, which looked at sexual offenses in these territories to try to identify what were the issues, how do we get people to come to the courtroom door, how do we provide greater access to justice. And the Juris study found that they were the same deep-rooted problems in the court system and in the justice system generally. Poor data collection, poor investigation, really, really pernicious gender stereotypes, a lack of consistency in terms of sentencing, a lack of consistency in terms of prosecution. All of these issues that you have seen in your project were present here. And we did two things. The Juris Project, together with our apex court, the Caribbean Court of Justice, and local judiciaries, and UNICEF and UNIFEM, partnered to produce a gender protocol for judges, which is aimed at introducing judges to the concept of gender-sensitive adjudication in a number of areas, not simply in the area of gender-based violence, but including gender-based violence, sexual harassment, sexual offenses, family adjudication, especially maintenance and custody, and human trafficking, as well as domestic violence. And the aim of the protocol is to train judges to regard their cases and regard their work, as we say, not with the eye of a craftsman, but with the eye of an artist, and to import and use the judicial function, the legitimate judicial function, to bring the aspect of non-discrimination and equality, the use of treaties into their adjudication in every single area. And we started with those 4 areas. As you did, we had train the trainer sessions where we trained judges to train other judges. Judges like being trained by other judges, really. And we produced a gender protocol, which is country specific and sets out the specific areas where gender stereotyping, discrimination, and lack of equality are rife. We drafted a model protocol, and so far, Belize, actually South America, but part of the English-speaking Caribbean, has introduced their judges and presented their judges with their country-specific protocol. Trinidad and Tobago has also done so, and we are waiting just for a little break in COVID right now so that we can introduce ours to our judges. We're generally working from home and we really want to present it in person, but we may not be able to manage that. So the gender protocol is one arm of how we tackle those implicities in judicial decision-making and encourage judges to look at their cases through a gender lens. The second area that we deal with is specifically sexual offenses. We suffer from a lack of data in the Caribbean. I could not tell you how many sexual offenses matters there have been in the last 5 years from territory to territory. That's the sort of information that this dashboard would be absolutely vital for us, as we know when we speak to the executive, when we speak to the state, when we actually have actual statistics and we actually have case studies, that's very useful. I can't tell you also what sentences have been meted out. I can't tell you what the average sentence is. We have the information is there, but we are disparate countries and we simply have not had the ability to do that. What we have had the ability to do is to study the court protocols, study the legislation, and study the investigative practices to look at the barriers to effectively adjudicating and supporting sexual offenses and victims of sexual violence. And we again found the same lack of access, the constant re-victimization of the victim, all of those issues that we are familiar with were very much highlighted. So the same committee, roughly the same committee that dealt with the gender protocol, also drafted the model guidelines to sexual offenses. And this is from the guidelines set out the best practices taken from throughout the world, not just the region. We looked at all over the world for the best practices in adjudicating sexual offenses. That is supporting the victim, preventing impunity, not re-victimizing, the proper processes for collecting evidence, the proper processes for directing the jury during the trial, supporting the victim, special needs necessary, also sentencing guidelines, because we operate from a perspective that we do have formal sentencing guidelines for most offenses. We just don't know the extent to which those guidelines are often followed unless they reach the Court of Appeal. And you know, with sexual offenses, the rate of conviction is so low, so few cases will reach the Court of Appeal. So we need this sort of intense study, and it's really a very exciting prospect throughout the region to see how are we doing? We have these guidelines. Are they working? We have the protocol. We have the sexual offenses guidelines, but is it actually seeping into the judiciary? Are they taking the cases on board, the training on board? Is this being shown in their decision making? I did not know until very recently that this could be done, except with some enormous input from the state. Right now, we're in a COVID environment. We're already not very, we're poor countries. It's not even that we're not very wealthy. We're poor countries. To get that kind of support from the state to do that magnitude of research seemed really impossible until I heard about this program. In the Caribbean, I think it would make a huge difference in terms of strengthening our legislation where it is necessary. For example, not all countries have criminalized marital rape, for example. There are some countries where the definition of rape is difficult to really support. In Barbados, for example, although we made specific efforts to make rape a gender-neutral offense, our Court of Appeal recently held that under that specific legislation, supposedly gender-neutral, they interpreted it as a man not being able to rape a man. So the sort of information that would be able to turn a legislature's eyes towards sexual violence as a major issue and the lack of access that victims of sexual violence can have to the courts and the resulting social exclusion, which is a major issue for post-colonial societies like ours, would be absolutely vital. I really am impressed by the sheer volume of work that ICAAD has been able to do. We do have NGOs who would be willing to partner. We would be extremely pleased to welcome your work to the Caribbean. I can guarantee that you will find we have the groundwork. We have started training our judges. We started to do the research. We need to make that next step. And we feel that this next step is precisely this kind of project where we can actually say to our people and to the state, look, this is what is happening in the courts. This is how it is happening. And this is how we can try to stop it. So I'm really happy that you invited me to participate in this particular forum this evening. Well, it's evening here, because all of us are going towards a very similar goal. We're just approaching it because of our historical background, because of our societies and our culture. We're approaching it in slightly different ways, but it still remains true in the Caribbean that all of our studies still show 1/3, 1 in 3 of our women are victims of sexual violence. That figure is not going down in the least. In fact, we often hear that while the level of other crimes may go down, the level of sexual violence continues to be high. And I would be very, very happy to welcome ICAAD to this region and to participate in what I consider to be the next revolutionary stage of our battle and our legitimate battle against gender-based violence. So thank you for having me.
Amazing. Thank you so much, Justice Cornelius. I think we've seen the similar, what you were describing, almost the running start towards this type of change. And it's really, really exciting to see those early discussions with our partners in Barbados have pointed to some really great opportunities, and we're thrilled to move forward in that direction.